Well, as everyone knows at this point, I lost my father over the weekend, and I am at the funeral services both today and tomorrow, Monday and Tuesday, for that event. And I wanted to give you a video that provides you the information on the last section of the notes that we're doing for the judicial branch. So, this is the section in your booklet, the last section, the third lecture that we would do on the judicial branch. You will just use this video in order to complete those notes. So we're looking at the U.S. Supreme Court as an overview in this final section of the information for to fill out your notes. And it is the highest court in the United States. It has the final say in all judicial matters. It was established by the Article 3 in the U.S. Constitution. And as we've talked about before, their power of judicial review was later solidified in the landmark case Marbury versus Madison, and that there are 9 justices that serve on the court. Although that number has fluctuated over time, there has not always been 9 justices on the court. There has been for some time. That is the number of justices on the court. Well, in order to serve on the Supreme Court, you have to be appointed by the president, and the second step in that process is to be confirmed by a majority of the United States Senate. And you can see that the most recent Supreme Court appointee was Ketanji Brown Jackson. She was appointed by President Joe Biden in June of 2022. Now, there's no official requirements in the Constitution in terms of who could be appointed as a Supreme Court justice. The president can appoint whoever he wants to serve in that position. Now, it's not guaranteed that that person will be confirmed by the U.S. Senate, but technically the president can nominate anyone he chooses to nominate. Now, the common qualifications for a Supreme Court justice would include things like experience as a judge. Somebody who has served in the criminal justice system at some level, has some experience, maybe a lot of experience in those areas of criminal justice in the court system. Recently, presidents have tended to choose somebody who is on the younger side of those who have experience within legal matters. Usually at least 40 years old at the time of appointment, oftentimes a little bit older. But the key thing in terms of who presidents appoint for Supreme Court justices is that a president wants somebody who's going to serve for a pretty lengthy period of time. They want to choose somebody who is in their 50s so that they can serve 20, 30, maybe even 40 years in that office or that position, that role that they've been appointed to. That gives the president the ability to impact the Supreme Court in a much longer fashion rather than just a few years or even 10 years or so. So how do the justices get appointed? Take a look at this video.
There's a job out there with a great deal of power, pay, prestige, and near-perfect job security. And there's only one way to be hired: get appointed to the U.S. Supreme Court. If you want to become a justice on the Supreme Court, the highest federal court in the United States, 3 things have to happen. You have to be nominated by the President of the United States. Your nomination needs to be approved by the Senate. And finally, the president must formally appoint you to the court. Because the Constitution doesn't specify any qualifications, in other words, that there's no age, education, profession, or even native-born citizenship requirement, a president can nominate any individual to serve. So far, 6 justices have been foreign-born. At least one never graduated from high school, and another was only 32 years old when he joined the bench. Most presidents nominate individuals who broadly share their ideological view. So a president with a liberal ideology will tend to appoint liberals to the court. Of course, a justice's leanings are not always so predictable. For example, When President Eisenhower, a Republican, nominated Earl Warren for Chief Justice, Eisenhower expected him to make conservative decisions. Instead, Warren's judgments have gone down as some of the most liberal in the court's history. Eisenhower later remarked on that appointment as the biggest damn fool mistake he ever made. Many other factors come up for consideration as well, including experience, personal loyalties, ethnicity, and gender. The candidates are then thoroughly vetted, down to their tax records and payments to domestic help. Once the president interviews the candidate and makes a formal nomination announcement, the Senate leadership traditionally turns the nomination over to hearings by the Senate Judiciary Committee. Depending on the contentiousness of the choice, that can stretch over many days. Since the Nixon administration, these hearings have averaged 60 days. The nominee is interviewed about their law record, if applicable, and where they stand on key issues to discern how they might vote. And especially in more recent history, the committee tries to unearth any dark secrets or past indiscretions. The Judiciary Committee votes to send the nomination to the full Senate with a positive or negative recommendation, often reflective of political leanings, or no recommendation at all. Most rejections have happened when the Senate majority has been a different political party than the president. When the Senate does approve, it's by a simple majority vote, with ties broken by the vice president. With the Senate's consent, the president issues a written appointment, allowing the nominee to complete the final steps to take the constitutional and judicial oaths. In doing so, they solemnly swear to administer justice without respect to persons, and do equal right to the poor and the rich, and faithfully and impartially discharge and perform all the duties incumbent upon a U.S. Supreme Court justice. This job is for life, barring resignation, retirement, or removal from the court by impeachment. And of the 112 justices who have held the position, not one has yet been removed from office as a result of an impeachment. One of their roles is to protect the fundamental rights of all Americans, even as different parties take power. With the tremendous impact of this responsibility, it's no wonder that a U.S. Supreme Court justice is expected to be, in the words of Irving R. Kaufman, a paragon of virtue, an intellectual titan, and an administrative wizard. Of course, not every member of the court turns out to be an exemplar of justice. Each leaves behind a legacy of decisions and opinions to be debated and dissected by the ultimate judges, time and history.
So as you can see in the video, one of the things that presidents consider when making appointments to the Supreme Court is the political ideology of that justice and what they're going to do in terms of their future decisions on the court. And this is something called a litmus test. They are going to choose somebody who is most closely aligned with the political values that they themselves possess, either conservative or liberal. And so one of the things that often happens is presidents will choose somebody who's conservative or thought to be conservative in terms of their record and what they bring to the bench. But the reality is presidents don't know how those Supreme Court justices will decide cases moving forward as they take the bench and are confirmed by the Senate. So some presidents may consider sex, they may consider race. The historic makeup of the Supreme Court has been of white males, but the court has become more diverse since the 1990s. In fact, there have only been 6 women that have ever served on the court. 2 are deceased, and 4 are currently sitting on the bench as we speak. So one of the factors that in more recent years that presidents will consider is that makeup of a person's background in terms of their sex or their race to bring more diversity to the court. Also, the age of the appointee. I've talked about this just a few moments ago, that presidents typically want their appointees to serve for a solid length of time. So they're going to choose somebody who is rather younger and can serve a number of years. and have an impact on the court for, a decade or two, or maybe even more. This is the present day court as it stands. You have the current longest serving member of the court is Justice Clarence Thomas, who is right here in the front row. The Chief Justice of the Supreme Court is right here. This is John Roberts. The next person who has served the longest would be Samuel Alito. Samuel Alito was appointed by George W. Bush. And then Barack Obama had two appointments. He appointed Olega Kagan, which is here. She's here on the far right on the front row, and Sonia Sotomayor. Now, President Bush has had three appointees. His first appointee was Neil Gorsuch, which is here in the back row. His second appointee was Brent Kavanaugh, he's right here. And then you have Amy Coney Barrett, which is here on the back row on the left side. The most recent appointee is Ketanji Brown Jackson. She was appointed by Joe Biden during his term for president. So that is the current Supreme Court makeup. Again, you have 4 women, 5 men. One has served. In fact, Clarence Thomas has been serving since George H.W. Bush. He was appointed in 1991. So he has been serving over 30 years in terms of his length of time on the court. And so that is an example of somebody who has served a great deal of time on the court and has had an impact on some of the decisions and the direction of the court itself. So you have John Roberts appointed by Bush in 2005. He is the Chief Justice. Clarence Thomas, as I said before, appointed in 1991 by Bush Sr. Samuel Alito, appointed by George W. Bush in 2006. Sonia Sotomayor by Obama in 2009. Elena Kagan in 2010 by Obama. Neil Gorsuch was appointed by Trump in 2017. Brett Kavanaugh in 2018 by Trump. Amy Coney Barrett in 2020 by Trump. And then Ketanji Brown Jackson by Biden in 2022. Now, I want you to notice something here. Obama, who served 8 years, got 2 Supreme Court justice appointments during those 8 years. Donald Trump served 4 years from 2016 to 2020 and got 3 Supreme Court nominees and appointments. Biden got 1 in the 4 years that he was serving. So one of the things that is obvious by this is that some presidents can have a greater impact on the ideological makeup of the court based on the number of appointments that they have. And oftentimes those appointments are not expected. They are appointments that are unexpected in terms of people either dying in office or some other circumstance. Sometimes a Supreme Court justice will retire knowing that there is a president that aligns with their political ideology, or at least their philosophy in terms of judicial interpretation and judicial interpretation of the Constitution. So there may be a justice who will retire knowing that president might appoint somebody closely aligned with what they themselves would view as important. For example, Stephen Breyer was the Supreme Court justice who retired when Joe Biden appointed Ketanji Brown Jackson. Stephen Breyer would be considered somebody who would be a judicial activist, judicial activism in terms of his interpretation of the Constitution and applying various aspects of the law. And so he retired knowing that Joe Biden would appoint somebody that would be ideologically aligned with his values. So one of the things that you see is, in the process of appointing these justices, you will have, a lot of sharp contention over the nomination and the confirmation of these justices, because these are serious appointments, and they are lifetime appointments, as we're going to talk about here in a little bit. But historically, there have been very contentious hearings that have taken place for some of these justices because of their ideology. And this is primarily because these senators in the United States Senate know that these justices are going to serve 10, 20, even 30 years and help shape the judicial philosophy and the judicial rulings that will take place in the Supreme Court justice. So we're going to look at how a justice becomes a Supreme Court or a Supreme Court justice, how that process takes place. And one of the, according to the Constitution, the president nominates the justice and the Senate confirms them. And as the makeup, the ideological makeup of the court changes, so do the decisions of the court, and so do the precedents that those courts will consider moving forward. So I actually want to show you a couple of videos here of examples of the confirmation hearings of Supreme Court justices in the recent past. The first is going to be from Clarence Thomas. Clarence Thomas was a person who was highly qualified in terms of his qualifications to serve on the Supreme Court. But there were a lot of things that came up in his confirmation hearings that were quite contentious. And there were some very wild and very graphic accusations made against Clarence Thomas in the lead up to the vote to confirm him for the Supreme Court. And he was ultimately confirmed. It was not a unanimous vote by the U.S. Senate. It was, it was in a comfortable margin in terms of his confirmation process. But I think the video will play out how contentious that process was. And then immediately following the Clarence Thomas video, I want to show you, again, another contentious confirmation hearing, and that is from Brett Kavanaugh. Brett Kavanaugh was the second nominee by Donald Trump back in his first term. And there were, once again, accusations that came out against Brett Kavanaugh in terms of some things that he had done in the past. And there were people trying to intentionally sabotage and thwart his Supreme Court nomination so that the senators would not vote for him to serve on the Supreme Court. So take a look at these two videos here, and you can kind of see the tone and tenor. Again, the first one is from 1991, and so that was, a long time ago. The Brett Kavanaugh was more recent, 2018, and so when you're talking about Supreme Court justices in the recent past, these confirmation hearings are very contentious in terms of the senators from their ideological perspectives trying to ask questions that will pinpoint these potential justices in terms of their judicial philosophy. And then they will bring out especially very serious, what could be very serious moral charges against their character. And these are the kinds of things that can sabotage and thwart their confirmation more than sometimes the ideological aspect of their judicial philosophy and those kinds of things. So check out these two videos that I have for you.
This entire proceeding is ended.
With that gavel, Chairman Joseph Biden ended 3 of the most remarkable days in the history of the Congress. Senators investigating allegations of unwanted sexual advances by a Supreme Court nominee had waded out into uncharted and often seamy waters, hoping to arrive at the truth. But when the hearings ended at 2 o'clock this morning, 33 hours and 22 witnesses after they began, the Senate was right back where it started, having to weigh his word against hers. Anita Hill, a University of Oklahoma law professor, worked for Clarence Thomas during the early 1980s at the Department of Education and at the Equal Employment Opportunity Commission. She appeared before the Senate Judiciary Committee to tell her story.
His conversations were very vivid. He spoke about acts that he had seen in pornographic films involving such matters as women having sex with animals and films showing group sex or rape scenes. He talked about pornographic materials depicting individuals with large penises or large breasts involved in various sex acts. On several occasions, Thomas told me graphically of his own sexual prowess. Because I was extremely uncomfortable talking about sex with him at all, and particularly in such a graphic way, I told him that I did not want to talk about these subjects.
Judge Clarence Thomas had appeared to be within days of confirmation to the Supreme Court when the Anita Hill story broke. Now he was forced to return to the Judiciary Committee to defend himself, and did so with a blistering attack against his accuser, his opponents, and against the committee itself.
I would like to start by saying unequivocally, uncategorically, that I deny each and every single allegation against me today that suggested in any way that I had conversations of a sexual nature or about pornographic material with Anita Hill, that I ever attempted to date her, that I ever had any personal sexual interest in her, or that I in any way ever harassed her. A second, and I think more important point, I think that this today is a travesty. It's a national disgrace. And from my standpoint, as a black American, as far as I'm concerned, it is a high-tech lynching for uppity blacks who in any way deign to think for themselves, to do for themselves, to have different ideas. And it is a message that unless you kowtow to an old order, this is what will happen to you. You will be lynched, destroyed, caricatured by a committee of the U.S. Senate rather than hung from a tree.
Thomas continued to lash out throughout his testimony. When he concluded Saturday evening, Committee Chairman Joseph Biden lashed back.
I'm getting fed up with this stuff about how terrible this system is. I hear everybody talk about how terrible the primary system is. We're big boys. I knew when I ran for president, everything was free game. Anybody who runs for the Supreme Court or is appointed to the Supreme Court, to be more precise, should understand. This is not Boy Scouts. This is not Cub Scouts. In the case of the presidents, for the right to be leader of the free world, and no one ever said it would be easy. And whoever goes in the Supreme Court is going to determine the fate of this country more than anybody. For the next 20 years, we're going to have people, scrupulous and unscrupulous, respond and react. So, Judge, this is less directed at you than it is to my pontificating colleagues, Democrat and Republican alike. So, Judge, I have not made my judgment based upon this proceeding because we have not heard all the evidence.
Most members of the Judiciary Committee came away from the first 2 days of hearings agreeing on one thing. Both Hill and Thomas were credible witnesses, their testimonies powerfully convincing. The senators' hope was that the truth could be found somewhere among the 20 supporting witnesses who testified on Sunday. The rare Sunday session began with a panel of 4, each saying it was years ago that they independently learned of Anita Hill's problems with Clarence Thomas.
In the fall of 1982, Professor Hill shared with me in confidence the fact that she considered Judge Thomas's behavior toward her in the office to be inappropriate. Professor Hill did not at that time, nor in subsequent conversations, provide exact details about the actions she found inappropriate conduct. She did tell me they were sexual in nature.
She told me that she was being subjected to sexual harassment from her boss, to whom she referred by name. That boss was Clarence Thomas.
A second panel of 4, each having worked with Thomas and Hill at the EEOC, called the allegations preposterous and searched in vain for a motive behind Hill's accusations.
Everyone who knows Clarence knows that he is a very proud and dignified man. With his immediate staff, he is very warm and friendly, sort of like a friend or a father. You could talk with him about your problems, go to him for advice. But like a father, he commanded and he demanded respect.
What do you think, Ms. Holt? I think you know her the best of anybody on the panel. You think it is conceivable that Professor Hill might really think this happened when it didn't?
I think that's the only conceivable answer, Senator. Because I do not believe it happened.
In addition to the testimony, it was revealed that on Sunday, Anita Hill took and passed a lie detector test, according to the polygraph expert who administered it.
It was my opinion that there was no indication of deception to any of those relevant questions.
Under pressure from Republicans on the committee, however, Chairman Biden called the test inconclusive and announced the results would not be placed in the record.
If we get to the point in this country where lie detector tests are the basis upon which we make judgments and insist upon people having them, and by inference of those who don't have them that they did something wrong, we have reached a sad day for the civil liberties of this country.
It will be up to each member of the Senate to decide whether the test carries any weight with them. The vote on Clarence Thomas's nomination to the Supreme Court is set for 6 o'clock tomorrow evening.
Mr. Chairman, Ranking Member Feinstein, members of the committee, thank you for allowing me to make my statement. I wrote it myself yesterday afternoon and evening. No one has seen a draft or it except for one of my former law clerks. This is my statement. Less than 2 weeks ago, Dr. Ford publicly accused me of committing wrongdoing at an event more than 36 years ago when we were both in high school. I denied the allegation immediately, categorically, and unequivocally. All 4 people allegedly at the event, including Dr. Ford's longtime friend, Ms. Kaiser, have said they recall no such event. Her longtime friend, Ms. Kaiser, said under penalty of felony that she does not know me and does not believe she ever saw me at a party ever. Here is the quote from Ms. Kaiser's attorney's letter. Quote, simply put, Ms. Kaiser does not know Mr. Kavanaugh, and she has no recollection of ever being at a party or gathering where he was present, with or without Dr. Ford. End quote. Think about that fact. The day after the allegation appeared, I told this committee that I wanted a hearing as soon as possible to clear my name. I demanded a hearing for the very next day. Unfortunately, it took the committee 10 days to get to this hearing. In those 10 long days, as was predictable, and as I predicted, my family and my name have been totally and permanently destroyed by vicious and false additional accusations. The 10-day delay has been harmful to me and my family, to the Supreme Court, and to the country. When this allegation first arose, I welcomed any kind of investigation, Senate, FBI, or otherwise. The committee now has conducted a thorough investigation, and I've cooperated fully. I know that any kind of investigation, Senate, FBI, Montgomery County Police, whatever, will clear me. Listen to the people I know. Listen to the people who have known me my whole life. Listen to the people I've grown up with and worked with and played with and coached with and dated and taught and gone to games with and had beers with. And listen to the witnesses who allegedly were at this event 36 years ago. Listen to Miss Kaiser. She does not know me. I was not at the party described by Dr. Ford. This confirmation process has become a national disgrace. The Constitution gives the Senate an important role in the confirmation process, but you have replaced advice and consent with search and destroy. Since my nomination in July, there's been a frenzy on the left to come up with something, anything, to block my confirmation. Shortly after I was nominated, the Democratic Senate leader said he would, quote, oppose me with everything he's got. A Democratic senator on this committee publicly referred to me as evil. Evil. Think about that word. And said that those who supported me were, quote, complicit in evil. Another Democratic senator on this committee said, quote, Judge Kavanaugh is your worst nightmare. A former head of the Democratic National Committee said, quote, Judge Kavanaugh will threaten the lives of millions of Americans for decades to come. I understand the passions of the moment, but I would say to those senators, your words have meaning. Millions of Americans listened carefully to you. Given comments like those, is it any surprise that people have been willing to do anything, to make any physical threat against my family, to send any violent email to my wife, to make any kind of allegation against me and against my friends, to blow me up and take me down?
So you can see how contentious these confirmation hearings can get. And with the accusations that were made by Anita Hill to Clarence Thomas or about Clarence Thomas, and you saw in the video what kind of allegations that were made against Clarence Thomas. It was basically a he said, she said situation. There were people on both sides supporting Clarence Thomas and those who were supporting Anita Hill. So it was a he said, she said. He was ultimately confirmed with a 52-48 vote by the Senate. Again, very similar, you have the accusations by Dr. Christina Blasey Ford against Brett Kavanaugh in the 2018 confirmation hearings for his Supreme Court seat. Once again, it came down to a he said, she said. And so you see with Brett Kavanaugh's words there, his perception of the things that took place there and why those things took place the way they did. And the reason that these things are so contentious is because you have lifetime appointments for Supreme Court justices. According to the Constitution, Supreme Court justices are appointed for and serve for life under good behavior. Now, they can be impeached. There are impeachment situations for Supreme Court justices, but this is the reason why these seats are so contentious. Now, the average length of service for a Supreme Court justice is 16 years. But recently, this has been growing. The longest serving Supreme Court justice has been 36 years. And notice, you can see here that that is 36 years. William O. Douglas from 1939 to 1975. But Clarence Thomas, the individual, the justice that we saw his confirmation hearing there just a moment ago, he has been serving for 35 years. So he is close to eclipsing the longest serving Supreme Court justice in the history of the Supreme Court. And so you can see if a justice can serve 30 years or longer, that is a lengthy amount of time in which they serve on the court and exert their influence on the opinions that are produced by the court. And you can even see by the chart there the number of Supreme Court justices that span the length of 6, 7, even 10 presidencies in some instances of Supreme Court justices in which they have served. So the average length is 16 years, but there have been many justices that have served for over 30 years in terms of their lifetime appointment. So the framers wanted the Supreme Court to be politically insulated from pressures from the judicial branch, from the executive branch, so that they could make their decisions independent of those political pressures. And that is why Supreme Court justices and judicial appointments, all judicial appointments, have lifetime appointments to protect them from that political influence that may influence their decisions as they're sitting on the court. They serve for life. And so that is why, to a lot of people, this is such a high stakes, very important decision in appointing somebody to a position where they could serve for decades and have an impact on the court for decades. Now, in terms of the day in the life of the Supreme Court justice, the justices work from October through June. That is the length of their term for a year. And their main responsibilities include reviewing petitions that come before the court. They will hear cases. They will discuss, after they hear those cases, and they will discuss those cases, and they will vote on those cases, and then they will write opinions. So whatever the decision is for the court, if it's 5-4, if it's 9-0, there will be justices that will write opinions that will give people an understanding on why the court ruled in the way that they did. Now, if it's a split decision in terms of 5-4 or 6-3 or even 8-1, there will be a justice that will be assigned to write an opinion for the majority decision for the court. And then there will be an opportunity for justices that voted the opposite direction in the minority. They will be given the opportunity to write opinions as well. They'll be referred to as the dissenting opinions or the minority opinions in those cases. And they will lay out why, in fact, they voted no against that particular situation or not in favor of that court decision.
Being a Supreme Court justice is a once-in-a-lifetime opportunity, but it's still a job, and a grueling one at that. Here's what it's like being a Supreme Court justice. The day. The justices arrive around 8 a.m. and get right to work with their clerks. Each associate justice can have 4 clerks during a term, while the Chief Justice may have 5. The clerks will have culled through applications for the court to hear cases. About 7,000 to 8,000 petitions are filed each term. Justices and their clerks spend the morning discussing potential cases. The justices will make the final decision on whether a case should be presented to the other justices. Lunch is a collegial time free from discussion of ongoing cases or other controversial topics. Justice Ruth Bader Ginsburg has said that most days, Justice David Souter eats yogurt for lunch, although Justice Sonia Sotomayor has said he sometimes eats an apple as well. Sandra Day O'Connor, retired 2006, used to bring beef jerky. And John Paul Stevens, retired 2010, ate white bread cheese sandwiches sans the crust. Following their meal, the justices discuss recently argued cases. Later, they'll finish working on drafts of recent opinions so fellow justices can review the next day. Throughout the process, the justices exchange notes and debate the merits of each case until they arrive at a majority and a dissenting opinion, each written by a member of the majority and dissenting minority. Justice Ginsburg once noted that prior to her completing the majority opinion in U.S. v. Virginia, which ended the ban of women from Virginia Military Institute, the late Justice Antonin Scalia supplied her with his stinging dissent. His opinion, she said, made hers far better. The pay. Associate justices earn a salary of $255,300, while Chief Justice John Roberts makes $267,000. Retirement benefits are pretty good as well. Retiring Justice Anthony Kennedy can look forward to an annual pension equal to his highest full salary. Justices can also earn money from books and college lectures. Justice Ginsburg made nearly $205,000 in royalties from her 2016 book, My Own Words, and Justice Samuel Alito was paid $17,000 for teaching at Tulane University Law School's summer programs in Berlin and Paris, according to disclosure forms. They also make money from investments, though that can cause the occasional conflict. Justice Alito once had to recuse himself from a case involving Coke because he owned stock in the company at the time. Getting away. The Supreme Court is in session from the first Monday in October till late June or early July. During this time, they hear oral arguments. Following the term, the justices get a 3-month break, and the collegiality they develop on the court often carries over to their personal lives. Justice Elena Kagan often hunted with the late Antonin Scalia, and Scalia's friendship with Ruth Bader Ginsburg, who's on the opposite ideological spectrum, was legendary. Asked how he could be friends with someone who disagreed with him on so many issues, Scalia once replied that he attacked ideas, not people. If you can't separate the two, he said, you can't be a judge. In her spare time, Justice Ginsburg reportedly loves opera and is a devotee of the arts. Meanwhile, Justice Clarence Thomas prefers to connect with people and travels the country in a 40-foot recreational vehicle. While being a Supreme Court justice comes with some decent perks, there's also a ton of responsibility. As Justice Thomas once told California college students, being on the Supreme Court is an honor, but he wouldn't say he actually liked it. In fact, he lamented, there's no money and no privacy.
So there you have it. It gives you a little bit of idea about the life of a Supreme Court justice and what they do, what's involved in their decision-making process, and what happens throughout the year. So they review about 7,000 to 8,000 petitions a year. They choose roughly 80. We've talked about this before, looked at it before in terms of how they choose cases that they will hear, and that is chosen by the rule of 4. 4 justices have to agree in order to hear a case. Now, justices will grant, if they hear a case, what's called a writ of cert, a writ of certiorari, and that is an order for a lower court to send up the case files for review for the Supreme Court before they actually have the hearing before the lawyers that come present their cases. So attorneys on both sides will then submit briefs. These are written legal arguments for the court that contains their version of what they're trying to convey to the court in terms of trying to persuade the court to vote for their side. Sometimes there will be what's called amicus curiae briefs that are also submitted, and these are submitted by what's called friends of the court. That's what that phrase means. That's what that phrase means, the amicus curiae, friends of the court. And they are submitted by parties that are not involved directly in the case, but they have a vested interest in the case. For example, Planned Parenthood might write an amicus brief in a case that has to do with abortion, because though they may not be directly involved in the case, it may impact them, so they would have a vested interest, and they could write that amicus brief for the court to consider. So both parties will then appear before the Supreme Court, and each side will have 30 minutes to present their oral arguments. Now, during this time, the justices will ask questions of the attorneys. Sometimes it won't even be 30 seconds into the lawyer's presentation of that 30-minute oral argument before a justice might interject with a question for that attorney. And it may, go from a prepared 30-minute speech before the court to a back and forth between various justices and that lawyer that is presenting the case for their side of the argument. And so there's a lot of flexibility that a lawyer has to have when presenting their case before the Supreme Court, because they may have 30 minutes prepared for the court, but may not have, just minutes of what they prepared that they actually deliver before the court. They may be involved in just a constant back and forth and answering questions from the court and from the justices that they might have for that lawyer. So no video is allowed in the court. We only have audio and hand-drawn sketches, although the public is allowed to sit in on Supreme Court hearings. And the justices, after they hear oral arguments, they will discuss the cases and they will vote on those cases in private. And the order in which they vote on those cases will go by seniority. And once those decisions are made by the court, then they will follow the principle of what is called stare decisis, which means let the decision stand. That means that the court should follow the precedents that are set in previous decisions. And it is very rare for the Supreme Court to overturn a previous decision of a decision of the Supreme Court in the past, though that has happened several times. It is very rare for a court to overturn a decision because of this concept or principle of stare decisis, meaning let the decision stand. There has to be a circumstance or situation where the evidence is so compelling or the circumstances have changed so much to the degree that the current Supreme Court will overturn stare decisis and a decision that has been previously reached by a Supreme Court. And so what this does is it provides consistency. Consistency from perspective of the decisions coming from the Supreme Court. There, as I said before, there's not often that the Supreme Court will override or overturn decisions from the past, and this ruling or this rule is usually followed, but not always. For example, Brown versus Board of Education overturned Plessy versus Ferguson in one very famous example of a court overturning a previous decision in which they did not follow stare decisis. And also the Dobbs versus Jackson decision, which overturned Roe versus Wade very recently. So when there's a major ideological shift in the court, there will be circumstances where the court could, in fact, overturn previous precedents set by the Supreme Court in the decades previous to it. So in those decisions, a member of the majority is assigned to write the majority opinion, and the same is true of the dissenting opinion. And so justices will write those majority and dissenting opinions, but there also could be circumstances where justices could write what are called concurring opinions. So this would be those justices that agree with the majority, but they do so for different reasons, or they feel that they have something further to add to the decision. So there may be multiple opinions that are written for a majority decision from the court, one that is considered the official majority opinion, and then there are other concurring opinions as to why they voted for the majority. But that, again, they may agree with the majority, but they may do it for different reasons or feel that they have something further to add. And so at that point, the majority opinion sets what is known as precedent. And this is the decision or rule that is to be applied in all future cases. And again, using stare decisis, that precedent will stand unless there is an ideological shift on the court that would precipitate the court going a different direction in terms of deciding on that case. Now, if there is a tie in the Supreme Court, the lower court ruling will stand. So let's say that one Supreme Court justice abstains because of some conflict of interest. There could be a decision where there's a 4-4 ruling on the court. And so in that case, if there is no majority opinion, it is simply the fact that the lower court ruling stands. Now, there are checks on the judicial branch. The appointment process itself is a check on the judicial branch, where the president appoints, and it is the constitutional duty for the Senate to confirm those judicial nominations. They also can be impeached. So even though they are appointed for lifetime, life tenure, there can be instances where a judge, because of bad behavior or some other reason, could potentially be impeached from their judicial appointment. Also, there could be amendments to the Constitution. Let's say the Supreme Court rules on something, and a check on the judicial branch in terms of the majority opinion would be for Congress to pass or to vote for an amendment to the Constitution, and then the states to ratify that amendment to the Constitution. And that itself would be a check potentially on the decisions of the Supreme Court. The other thing is the judicial branch cannot enforce their decisions. And the reality is the judicial branch relies on the executive branch to enforce the decisions coming from the judicial branch. And so, for example, when Brown versus Board of Education was decided by the Supreme Court, there was no enforcement mechanism by the Supreme Court to enforce the idea that separate but equal was no longer to be allowed in the country. And at the time, the president was Dwight Eisenhower, and it fell upon the president himself to enforce the decision of the court and to provide protections for students who are being integrated into those situations. In fact, there have been instances in history where presidents have scoffed at the decisions of the Supreme Court. Presidents like Andrew Jackson and others have basically, ignored Supreme Court decisions and refused to enforce the decisions of those Supreme Courts. You could also have a situation where the Supreme Court rules against perhaps legislation, and Congress could go back to the table and revise and repass legislation that would follow the directions coming from the Supreme Court in order to make that legislation more constitutional in the way that it is framed and worded. Also, you can have adjusting the jurisdictions or even the number of justices on the court. Back in the 1930s, there was an effort by President Franklin Delano Roosevelt to add justices to the Supreme Court to try to impact the decisions and the opinions of the court. And of course, it was known as court packing, and it was something that failed on FDR's part. But in recent years, there have been a lot of people advocate for the position of adding Supreme Court justices in order to try to, as they would see it, balance the court ideologically. And so this is a way potentially that the legislative branch could pass laws that would add the number of justices to the court that a president could nominate and the Senate could confirm. And then the last one, and to wrap up this section and lecture on the Supreme Court, a check on the judicial branch informally or unofficially would be public opinion. And though this is not something that you would think would be very powerful, I mean, there is the idea of Supreme Court justices potentially being influenced by public opinion. Back when the Dobbs decision was being debated, it was leaked from Supreme Court somehow that this was a decision that was going to be forthcoming by the Supreme Court. And in the days and weeks following the leak of that decision that was reported that Roe versus Wade was going to be overturned, there was immense public opinion and pressure placed upon the Supreme Court justices. They were doxxed. Their addresses were put online. There were people that showed up in front of Supreme Court justices' homes protesting. the potential decision that was coming down in the Dobbs versus Jackson decision. There was even an individual who showed up at Justice Kavanaugh's house, in front of his house, with weapons, and he was arrested and charged with those crimes. So you can see how that, especially in very contentious times, that Supreme Court justices can be subjected to different forms of public opinion. And again, this is an unofficial check on the judicial branch, but it is something that can influence the direction of decisions coming from the Supreme Court. So there you have it. There's the information, the 3 lectures that we covered, the judicial branch. Where we're heading with this next, we're going to look at some Supreme Court decisions tomorrow and kind of look at how the Supreme Court decided in those cases. And then we're going to do a simulation. I'm going to break you up into a couple of groups, and you're actually going to do what the Supreme Court does. You're going to have a case presented to you, the facts of that case. You're going to look at past precedents that have related to that case. And then you're going to make a decision based on those past precedent and the facts of the case in order to come up with a decision as a Supreme Court of your own in this simulation, as you're going to do what the Supreme Court does in their work as very important work in the judicial branch, constitutionally, and upholding the Constitution in what they do.